check, check.
Hello, test. Hello.
Good evening, everybody. On behalf of the Honorable Chief Justice of India and the Secretary General of the Permanent Court of Arbitration, we once again extend a very warm welcome to all the judges, distinguished dignitaries, and invitees. It is with great honor and privilege that I welcome you to the valedictory session of our conference, International Arbitration and the Rule of Law. This event has been a joint effort of the Supreme Court of India and the Permanent Court of Arbitration in collaboration with Ansitral. We are honored to have amongst us Honorable Mr. Justice Suryakant, Judge of the Supreme Court of India, Mr. Tushar Mehta, Solicitor General of India, Mr. Damu Ravi, Secretary, Ministry of External Affairs, Mr. Gaurav Banerjee, Senior Advocate, Supreme Court of India, and Ansitral Cloud National Correspondent, and Dr. Tulio Di Giacomo Toledo, Senior Legal Counsel and PCA Representative in Singapore. We began this conference with the goal of fostering meaningful dialogue and debate among key stakeholders: the judiciary, legal practitioners, government officials, arbitral institutions, and international organizations. Over this weekend, you have generously dedicated your time to engage some of the experts in the field of international arbitration. Over the past 2 days, our distinguished panelists have not only illuminated pressing issues in international arbitration, but have also offered actionable solutions. Many of these insights have been enriched by the personal experiences of our speakers. To describe this conference as a success would not fully capture its significance. It has been particularly meaningful and an enriching experience, reflecting India's growing role and engagement on international arbitration. To begin the valedictory session, may I now invite Dr. Tulio Di Giacomo Toledo, Senior Legal Counsel and PCA Representative in Singapore, Permanent Court of Arbitration, to deliver his address.
Ladies and gentlemen, distinguished speakers, esteemed attendees, my colleagues, authorities, as we come to a close of this conference, it is my great privilege on behalf of the Permanent Court of Arbitration to extend our heartfelt thanks to all of you for being part of this special occasion, the celebration of the 75th anniversary of the Supreme Court of India and the 125th anniversary of the PCA. Over this weekend, we have witnessed thought-provoking discussions on international arbitration, a wide variety of topics and issues. But let's step back. We often think, or like to think, international arbitration as a well-defined entity, or perhaps an animal, that is often becoming more and more part of our legal profession. However, the sessions yesterday and also today reminded us that international arbitration does have its ramifications. We heard yesterday that in interstate arbitration, there is a period of resurgency that is taking place. After being widely used to settle differences between states in the late 19th century, interstate is becoming again mainstream. The PCA, as noted by Rod Bundy, woke up from a period of slumber and immediately regained the trust of the international bar. The PCA grew and became once again a very active in the field of interstate dispute settlement and arbitration. Interstate and the PCA resurged, but also international law and best practices in the field have also developed, as Sean Augie showed us that the field is still in development, in particular in respect of provisional measures and requests for interim relief. Our speakers have confirmed that many of what we already knew in respect of commercial arbitration, that there's also a moment of growth in the field. With more growth, more actors become evident. Mr. Kavinder Bull has shared with us how the role played by state courts are becoming more prominent, even in cases where minimal courier interventions remain the standard. During the same panel, Mr. Salim Mulan has noted that seat courts seem to be departing from practices in applying conflict of law rules to determine the law applicable to the dispute. And more policy considerations seems to be gaining place. Manisha Singh has shared her perspective on the developments in India, speaking about as well the role played and how international arbitration is becoming more and more prominent and how it can become even more prominent here. Speaking about the role played by other actors in arbitration, my colleague earlier today, Sandra Magalangan, provided some insights on the role of designating and appointing authorities, in particular on how the appointment process takes shape inside the PCA. But when it comes to investor-state arbitration, the word that we have heard the most is perhaps reform. Justice Malhotra reminded us of some of the concerns surrounding the current system. The issues around and the call for reform was expertly framed by the Chief Justice, as well as by Toby Landau in his intervention yesterday. Professor Paulson spoke about some of the issues in the current system that he has personally experienced, confirming the issues and that reforms may indeed be needed. We spoke about possible solutions, some of them immediate, some of them on the long term. Mr. Nicholas Peacock invited us to pay extra attention to mediation of investor-state disputes, providing us a useful roadmap for the process. And even if arbitration becomes inevitable, Nusha Basir reminded us that the parties and the tribunal do not need to cease their efforts and could take advantage of procedural tools to further engage in settlement discussions during the arbitration process. V.K. Raja shared his concerns about the unlevel field that international arbitration often is and praised their efforts to establish an international advisory center to make the arena fairer. But what all speakers seem to agree is that no institutional reform currently being proposed will solve the issues discussed here. Pramod Nair invited us to reconsider the role interstate dispute settlement can play in settling investment disputes, and also George reminded us of some of the incentives that are often forgotten for signing BITs and engaging into investor-state arbitration. Again, all seem to agree that ISTS could be more inclusive. And we hope that this conference serves as an opportunity to share experience, learn, or at least make new friends. But on that note, I would like to mention as well that during the course of the conferences, there is one seat that seemed to be emptied and was not left unnoticed. Mr. Fali Nariman, a longtime friend of the PCA, was mentioned, and his legacy seemed to continue in the hearts of many of us right here. I personally met Mr. Fali Nariman during one of the PCA India conferences that was held in 2018. I'm not here to say how important and how his legacy is enduring, but I can say that from the perspective of the PCA, he was fundamental in bridging and bringing both the PCA, India, and its legal community closer. So also, on behalf of the PCA, I would like to dedicate this conference to the memory of Mr. Fali Nariman. And lastly, on behalf of the PCA, as well as the organizing committee, I'd like to thank you very much, first the Supreme Court for being the co-host, but also in particular the Chief Justice for his support for this conference, Mr. Attorney General, Secretary Mr. Tamuravi, as well for your support, Mr. Gurab Banerjee, Justice Indu Malhotra, as well as our colleagues, Mr. Pramod Nair, Manisha Singh, George, my colleagues from the PCA. You have seen some of them here, Sanya, Sandra, but also other colleagues in The Hague, as well as all our volunteers, and I specifically name here Ojal Shita, Ahmed, and others. Also special thanks to all the speakers that made their way to Delhi, some of them on a very short notice. I'm very thankful for taking the time and the effort for being here, as well as for the judges moderating the panels, the members of the registry, and also in particular the audience for your participation and engagement. Again, on behalf of the PCA, thank you very much.
Thank you, Dr. Tulio, for your address. May I now request Mr. Gaurav Banerjee for his address today.
Honorable Justice Suryakant, Judge Supreme Court of India, Shri Tushar Mehta, the Learned Solicitor General for India, Mr. Dammu Ravi, Secretary MEA, Dr. Tulio Di Giacomo Toledo, I hope I've got that right, PCA representative, distinguished judges, past and present, speakers from near and far, and my dear friends and colleagues. It was just 2 days ago that the conference was inaugurated by the Chief Justice of India in the presence of the Secretary General of the PCA and the Secretary Ansitral. We were told about the significance of the event, bringing together two towering institutions, one in its 75th year and one in its 125th. Yet I must confess that I did not truly appreciate at that time the real significance of the occasion. At the close of this landmark event, having attended all the working sessions which brought together the finest legal minds, experts in the field of arbitration from India and abroad, I can say with confidence that it has been quite a learning experience for me. I have learnt of many interesting things, some perhaps not to be repeated. But rather than reflecting on any of the sessions, because Tulio has summarized some of the sessions and their impact, I wanted to talk about one extraordinary individual whose name has been taken on a few occasions during the course of the conference. As some of you may know and must have known by this time, Fali Nariman was the guiding light and the driving force behind organizing 3 PCA conferences before this one. In fact, he went further, and with the cooperation of Mr. Dammu Ravi, who's sitting here, under his chairmanship, we at the UNCCI also organized a workshop. I believe it was June 22, for capacity building of government officials in ISDS, an esoteric subject, by drawing upon the knowledge and experience of some of the best minds across the globe. We had it was all virtual. We had speakers from all over the world. We had many officials and it was a 3-day event, and I believe it was the first of its kind, at least for our government officials. Even this conference, which we are attending today, was Fali's brainchild. It was only because of him that the gap between the Supreme Court and the PCA was bridged, and Ansitral was the bridge, and they helped in the collaboration, and he had something to do with the selection and the topics as well. So I thought to myself, what would Fali have said had he been here today? After hearing all this, what would he have said? What are the insights that he would have had? Obviously very difficult to guess, because Fali Nariman is obviously very special. I do have some insights into his views on arbitration recently, because we were assisting him in a case which he was very keen to argue before the Constitution bench. Unfortunately, he passed on. Matter has been argued, judgment has been reserved, and he had many thoughts, but I will restrict myself only to a couple of comments that he would have had he been here. But before I go to the two insights of Fali, one other source that you might care to look at is, he wrote 2 books, very pithy books on arbitration, titled Harmony amidst disharmony. And I invite you to read them. They are quite not very bulky, quite thin. One is on domestic arbitration, one is on international arbitration. But every time I read that book, I discover something new. It's 200 pages each. Every time there is something new, and I wanted some inspiration, so I went through the books again. So first on the international front, and his thoughts on ISDS. He recognized, as everyone does now, though he recognized it much earlier, that the attempt to resolve ISDS disputes by ad hoc arbitration in the conventional manner now appears to have failed. So the present system has a problem. This all of us recognize now. There was some controversy earlier. There were some strange comments made a few years ago about criticisms of ISDS, but now everybody's on the same page. But what is that point that he made? That was, in fact, the point he was made was tangentially touched upon by Justice Amanullah in Working Session 3 yesterday. And this is what Fali said. George also mentioned it, and I quote. And this is a quotation which will resonate with a lot of people, both internationally and domestically. And this is what he said. Those outside arbitral halls appear not to be too enthused with the manner disputes are being currently resolved. The point he is making is very clear. We as so-called domain experts or arbitration practitioners continue speaking to each other while not considering the most important player in the dispute, namely the party. The party is much more important than the other actors. In investment arbitration, it's the investor and of course the state whose views should be paramount. So when we start criticizing states, states have their own reservations, and importantly, as pointed out by Mr. V.K. Raja, different states may have differing motivations. India has gone from capital importing to capital exporting, and it has to keep its own interests in mind. And who are we as arbitration practitioners to tell states what to do? We must keep the party who's outside the arbitration hall in mind. That's the first insight that he had, and I think that resonates even today. The second insight, which I think you will find very interesting, is flows from the title of the conference. If you see the title of the conference, it says International Arbitration and the Rule of Law. Now, frankly, according to me, there is some sort of tension between international arbitration as it functions in practice and the rule of law. Indeed, there's some tension between domestic arbitration and the rule of law. Some would say that they are antithetical to each other in the way that it actually plays out. But the purpose of any dispute resolution process is to arrive at a just and fair conclusion consistent with the rule of law. And the reality is, in domestic arbitration, we are facing a crisis of confidence amongst the users. There is a crisis of confidence. Government has views, individuals have views about the state of play. So does Mr. Fali Nariman or his book offer any insight? While leafing through the book, I found a very interesting reference to a speech delivered in 1983 by a gentleman by the name of Professor Pierre Lalive, who is a distinguished Swiss arbitrator. He was speaking at the 60th anniversary of the ICC Court of Arbitration, and he was addressing obviously arbitration practitioners. And from the podium, he reminded them of 3 basic points which arbitration lawyers tend to forget. 3 basic points, and I'll mention them, and it's extracted in his book. First and foremost, arbitration is not a panacea for all evils. It is merely a means to an end, which is to get a just result. I am sorry to say this, arbitration is nothing special. It is a process and not an end point. We as so-called domain experts must remember this. Arbitration is a process. Second point he made. This is all in the context of international arbitration, but it equally applies to our domestic field. Second, merely because there is an award, it does not give the award sanctity. There are good awards, there may be bad awards. Internationally, you may have what are called lawless awards. A bad award should be set aside in the interest of the arbitration community as a whole. We are continuously fed this theory, minimal court intervention, don't touch awards. The reality is arbitration is a process. There are good awards and bad awards. Third and most importantly, Pierre Lalive speaking, courts have and must retain supervisory jurisdiction. There is no such thing as unfettered autonomy in a private process. After all, the result has to be consistent with the rule of law. Fali was disturbed by some of the developments on our domestic scene. We need to find homegrown solutions to make arbitration consistent with the rule of law and acceptable to its users. Having flagged these issues, it only remains for me to acknowledge the contribution of those present, not only in the auditorium and outside. I would firstly like to express my gratitude to the Chief Justice, who took a particular personal interest in the conference. I thank the distinguished judges of our highest court who took out time to preside over the working sessions. We were privileged to have speakers from across the globe, many of whom are legendary figures in the international arbitration community. I thank them all. I, as the chair of UNCCI, along with my colleagues, would like to express our gratitude to the PCA Secretary General and his team, and to Secretary Uncitral and her team for their efforts in organizing the conference. The MEA, Mr. Dammu Ravi is here, was of enormous help. The Supreme Court Registry was incredibly helpful. I want to thank my colleagues at UNCCI, Pramod Nair, George Pothan and Manisha Singh. I must make a special mention of our volunteers. They are from various law schools, including NLU Jodhpur, NLU Delhi, Jindal. Your engagement and enthusiasm has made this conference a success. I extend my heartfelt thanks to the audience, and we had a lot of distinguished judges here, senior advocates, lawyers, people from government. As we conclude the conference, I am filled with optimism for the future. The insights and ideas exchanged over the past few days remind us that while we may come from different legal traditions, cultures and nations, we are united by our shared commitment to justice and the rule of law. We look forward to seeing you in the next conference. Thank you.
Thank you, Mr. Banerjee, for your address. May I now request Mr. Dammu Ravi, Secretary, Ministry of External Affairs, to address this gathering.
Honorable Justice Surya Kant, Learned Solicitor General Sri Tushar Mehta, Dr. Tulio Di Giacomo Toledo from the PCA, Dr. Gaurav Banerjee, judges of the Supreme Court and High Court, legal luminaries, practitioners, students of law, academicians, ladies and gentlemen. It's a proud privilege and honor for me to be here today at this valedictory function. And I know in these last 2 days of very vibrant sessions on this very important international arbitration and rule of law theme, there have been new insights, vibrant exchanges, and friendship reinforced amongst the colleagues that have participated in these 2 days. For me and my colleagues in the Ministry of External Affairs, it's indeed a great honor to be part of this important event. At the outset, I would also like to congratulate the Supreme Court on the 75th anniversary of its founding. In the service of the nation, it has indeed upheld the rule of law and ensured fairness and justice year after year. I also like to congratulate the Permanent Court of Arbitration, the oldest arbitral institution celebrating its 135th anniversary. And if I have to bring back the idea of the Secretary General Marcin Sepelak. It is a celebration of 200 years of collaboration and partnership between the Supreme Court and the PCA. This soft launch that happened the day before yesterday of the PCA office by Honorable Chief Justice of India marks a major milestone. It forges even more intimate partnership between India and the PCA. We are currently doing renovation, and we are hopeful that very soon it will start to function. PCA could not have asked for a better location than what it has got. It's very close to Supreme Court, it's very close to Chambers of Commerce and Industry, and more importantly, the government offices and the legal luminaries that are concentrated in this part of India, Delhi. I would like to throw some ideas, because this is an important subject and an important gathering that I would like you to reflect upon. One of which is the rise of India, which many of us know it's an inevitable juggernaut. We would be $4 trillion economy GDP very soon. 5 trillion is doable in near future, 10 trillion in the not so distant future, and 30 trillion, though seem a tall order, is definitely achievable. And this is all fitting in to the Honorable Prime Minister's vision for India's Amrit Kal 2047. The economy growing at 7%, we are all confident that India will create its own heft, and this economic momentum will accelerate to reach the target. But more importantly, the dynamism of the entrepreneurship, that is looking at new frontiers, becoming global, developing global brands, and supplemented by the creative talent, the innovative minds that are there supporting the economic activity. We are confident that India will reach that milestone. It's already showing in the way the foreign direct investments are pouring into India. It's about $900 billion cumulatively for over 2 decades. But what is more important is outgo of capital too. It's about 1/3 of that, which is $300 billion outside of India, which means that Indian companies are becoming global and are reaching new frontiers and doing collaborations. But what it also tells us, I want to put this into perspective, that dispute is become natural. It's not about ring fencing oneself against disputes. Disputes become natural when the economy is growing. And that means mediation, reconciliation, and arbitration become part of that. We have to recognize that these are intrinsic part of the economic growth. The only way to handle this is not to ring fence, but to get into the fence and play by the rule book. And we need to become experts and skillful at doing it so. And that comes with a lot of discipline and patience, and a collective effort of all of us to ensure that we are able to create an ecosystem for a very good arbitration that evokes confidence amongst the entrepreneurs and investors in the country. It is also important for us to reflect the flip side of it, because if you don't have a good system that is addressing the arbitration issues, the disputes, then the real investments will not flow in. What we will also see eventually is more of brownfield investments, not greenfield investments. And that's very dangerous for an economy, because in a brownfield investments typically chipping away your assets, and that's also chipping away your sovereign asset of the country. We would need more greenfield investments, and that's possible only if we're able to ensure a good ecosystem for dispute resolutions. I'd like to also throw the idea of the WTO and why this is so important for a country like us today, because the World Trade Organization dispute settlement mechanism is dysfunctional. Trade and investments are so interlinked concepts, so we need to ensure that in the absence of the dispute settlement mechanism in the WTO, we need to have good remedial measures, which is the arbitration processes and procedures should be in place. Another idea that's important to focus on is the ISDS. A lot has been talked about in these few sessions recently, the investor-state dispute settlement mechanism. And why this is important for developing countries is because the ISDS particularly focuses on profit and not so much in terms of the development perspective of a developing country. There's been a talk about Secretary Ancestral Ms. Anna Rubin Brett talking about reform of the ISDS, and that's very much needed. In the Ministry of External Affairs, the delegation we sent for the ancestral meetings, we would like to bring this idea of responsible investments, that the investments that come into developing world has to be much more development oriented, but not treaty shopping, not taking advantage of the changes in law. It's important to also recognize that developing countries have an obligation to deliver to its own people, so which is why so often the investment law becomes very dynamic. It keeps changing for the better. But it doesn't mean that investor is losing. But investor has to look at it from the point of view of where the economy is growing. Ministry of External Affairs has been the repository of a lot of case laws on the arbitration, investment related. And we've been providing support to line ministries and departments in fighting cases. We have an excellent arbitration cell headed by my Joint Secretary Abhishek Singh and his team, Rushal Garg, Sindhu Acharya, they're all here today. And for a long time, George Porton was the backbone of this arbitration cell. But we know that in the days to come, as we anticipate more cases and those disputes, we would like to expand the arbitration cell. Eventually, it is the global south which will have to take advantage of the PCA that we are setting up. Because many of these countries in the global south do not have the institutions that are required to fight cases for them, nor do they have capacities. It is also our responsibility to ensure that countries in the global south have a facility to take up their causes. And we would like to use our missions across, almost 200 of them around the world, to generate awareness about what India can offer in terms of commercial dispute resolution and arbitration capacities. I'm sure and confident that the PCA that will come up, eventually start working from the beginning of next year at least, will not only look at the cases, arbitration, but also does conferences and capacity building. We will work very closely with PCA to ensure that it has success and it will have enduring presence in India. Before I close, I would like to particularly thank people who have really worked behind the scene in making this setting up of the PCA possible. First is the Honorable Chief Justice of India, D.Y. Chandrachud. Honorable Attorney General R. Venkat Ramani, Justice Indu Malhotra, Mr. Gaurav Banerjee, Manisha Singh, Pramod Nair have been behind this. The energy and the focus and the persistence they gave for the Ministry of External Affairs had made this possible. I thank you very much.
Thank you for your address, Mr. Ravi. May I now request Mr. Tushar Mehta, the Solicitor General of India, to address the gathering.
Good afternoon, everyone. Honorable Justice Suryakant, Justice Vishwanathan, Honorable Chief Justices from various high courts, Honorable Judges, Dr. Tulio, Sri Damu Raviji, Secretary, Ministry of External Affairs, my dear friend Gaurav Banerjee, and distinguished dignitaries. On behalf of the Government of India, I welcome the Permanent Court of Arbitration in India. And there are reasons why. We have all the reasons to welcome you with open heart. Arbitrations involving Indian parties are increasing day by day, and going by the number and value, as per the record of the Singapore International Arbitration Center, India is top foreign user since last 4 years. Notably, India has now moved up from 142nd place, which we were in 2014, and I'm giving the figures of the last 10 years. Out of 109 countries, India was 142nd in the ease of doing business as per the World Bank's ease of doing business report. Now, India has jumped in 2023 to 63rd position, and this is one of the key reasons why there is more and more foreign investment coming into India, resulting into the diversity of the litigation which can be taken care of as arbitration to be the preferred mode of arbitration of dispute resolution. Majority of Indian arbitrations are domestic, but the institutional arbitration is also going on simultaneously and has been increasing. The faith and trust of the litigating parties in the system of institutional arbitration is increasing. Now, I'll share with you, and you must have become aware by now after all these sessions, what are the reasons why India is a preferred choice for arbitration. The first reason is a very limited scrutiny at the stage of reference to the arbitration. Apart from the arbitrations which are based upon the contract and therefore necessarily individual arbitrations, when there is an institutional arbitration or a dispute between the two parties about the appointment of an arbitrator, the matter shall necessarily go to, in case of domestic arbitration, the highest constitutional court of the state, and in case of an international arbitration, to the highest court of the country, that is Supreme Court of India, and it is decided by the Honorable Chief Justices or that designates, be it another Honorable Judge or an institution. This accelerates the appointment of arbitrator, and majority of the time which is wasted otherwise, or which used to be wasted otherwise, is taken care of. We had a confusion in the legal interpretation. What would be the parameters within which the Chief Justice or his designate would decide whether to refer a matter to arbitration or not? Whether is it permissible to go into the questions, the dispute raised between the parties, and now we have a constitutional amendment as back as in 2015 which confines the examination only on the existence of arbitration clause. Whether it is arbitrable, the dispute needs arbitration, etc., is not to be gone into. That would be gone into only when the arbitration commences. This was a major stumbling block. Major portion of delay in reference to the arbitration was attributed to this delay, which is taken care of by the amendment, and the Honorable Supreme Court has also clarified in a recent judgment of Vidya Drolia's case. Friends, the recent judgments also recognizes the incentive which a litigating party would have in the arbitration, apart from being party autonomy. One of the incentive is the speed, the expeditious nature of this particular remedy. There are several statutory provisions which are made to ensure that the arbitration is over within a time-bound period. One of the provisions is requiring an arbitration to be over within a period of 1.5 years. Those who are aware of the Indian Arbitration Act would be aware, but I am pointing this out with a view to ensure that a word goes from India that we have a provision to ensure that the arbitral disputes are put an end to in an expeditious manner. We recently carried out an amendment in 2019, which is yet to be notified, but it permits the arbitral tribunal to be constituted by institutions. This would not only reduce the burden of the honorable courts, but would also expedite and ensure transparency and dependability if a neutral institution is appointing the arbitrator. Another reason for the success of arbitration is that in Indian court, we have recognized one new phenomena. There is a difference of treatment while enforcing an arbitral award between domestic award and a foreign award. In case when there is a international commercial arbitration and a result is award in favor of the one of the parties, then the enforcement court is not supposed to go into the question of patent illegality, because patent illegality is a phrase which is too objective and may differ from one court to another court. This is to ensure and to incentivize international commercial arbitration coming into India. India already is having flow of money, investment, infrastructure and talent. The only thing which is lacking is a reasonably speedy and dependable system of dispute resolution. Now the new amendments and the judgments, the interpretation of law given by the Supreme Court of India ensures that this takes place. Recently, there is a landmark decision in case of Avital Post Studios Limited. I believe someone must have made a mention during the previous sessions, where appellant resisted the enforcement of a foreign award which was passed in Singapore. One of the main grounds for resisting the award was that since the presiding arbitrator had failed to make a proper disclosure of material facts concerning his conflict of interest, and therefore the award was in violation of public policy, which is one of the grounds under section 48(2)(b) of the Indian Act. I'll read one paragraph from the judgment because according to me, from the perspective of Permanent Court of Arbitration, this law and this dicta of the Supreme Court would be very, very relevant. I quote, "Embracing international standards in arbitration would foster trust, certainty and effectiveness in the resolution of disputes on a global level. The above discussion would persuade us to say that in India we must adopt an internationally recognized narrow standard of public policy. When dealing with aspects of bias, it is only when most basic notions of morality or justice are violated that this ground can be attracted." Then the Supreme Court refers to several other judgments delivered by it in past and says, "In view of the above discussion, there can be no difficulty in holding that the most basic notions of morality and justice under the concept of public policy would include bias. However, court must endeavor to adopt international best practices instead of domestic standards while determining bias. It is only in exceptional circumstances that enforcement should be refused on the ground of bias." Then we come to the actual conduct of arbitral proceedings, and the experience had been that there is kind of delay in disposal of the arbitral by the arbitral tribunal. What we are anticipating is good, dependable arbitrators whose arbitral awards can be trusted. Second, the arbitrator, be it a single arbitrator or a panel of arbitrator, is not burdened with so much of the arbitration work that it cannot devote sufficient time. There is a specific provision made under section 12 of the Arbitration Act, which requires a potential arbitrator to declare the way in which international community also functions. Our Indian system also functions that way, so far as the statutory provision is concerned, where he has to declare whether he will be able to devote time for the purpose of effective and timely conclusion of arbitral proceedings. Our efforts are to ensure that this provision is respected and complied with in letter and spirit, so that the arbitrators who are having more work than they can handle, which results into unnecessary and avoidable delay, can be taken care of. Friends, India is the nation where the very concept of arbitration has evolved. It is only codified later, but by nature, Indians are not litigative, and they always resort to an arbitration, whether it is systematic statutory arbitration or other arbitration. I welcome the Permanent Court of Arbitration to India. They have come, though they have come late, but they have still come in time, and I hope and trust that with eminent people, eminent domain experts in the field of arbitration which are available in India, it would do a great job, and the system of arbitration would succeed and progress. I'm thankful that I'm called. I'm thankful that I got an opportunity to address every one of you. I am conscious of the fact that valedictory function is the most difficult function to tolerate for the audience, and therefore I'll not take any further. Thank you so much.
Thank you for your address, Mr. Mehta. It is now time for the final valedictory speech, which will be delivered by Honorable Mr. Justice Suryakant, Judge, Supreme Court of India. If I may take a few minutes to introduce Honorable Justice Suryakant. Honorable Justice Suryakant was elevated to the Supreme Court in 2019. Before his elevation to the Supreme Court, Justice Suryakant has served as the Chief Justice of Himachal Pradesh High Court and as a judge of the Punjab and Haryana High Court. Before his elevation to judgeship, he has had a distinguished legal career spanning over 20 years. He also has the distinction of being appointed the youngest Advocate General of the state of Haryana. May I now request Honorable Justice Suryakant to address the gathering.
Justice Vishwanathan, my esteemed colleague from the Supreme Court of India, distinguished Chief Justices and Honorable Judges from various High Courts of India, Mr. Tushar Mehta, Learned Solicitor General of India, Dr. Tulio Di Giacomo Toledo, Senior Legal Counsel and PCA Representative in Singapore, Mr. Damu Ravi, Secretary, Ministry of External Affairs, Mr. Gaur Banerjee, Senior Advocate, Unsettled Cloud National Correspondent and UNCCI Chair, Learned Additional Solicitor General of India, President and Office Bearers of the SCORA, learned jurists, arbitrators, advocates and academics, learned Secretary General and other officers of the Supreme Court of India, and most importantly, my dear students. Ladies and gentlemen, Namaskar, good evening. It is my proud privilege to be here with you at the valedictory ceremony of this momentous occasion. This international conference commemorates 75 years of establishment of the Supreme Court of India and 125th anniversary of the Permanent Court of Arbitration. The coming together of these two historic institutions has truly been an incredible endeavor, and I am sure this relationship will continue to blossom further with time. I would like to appreciate the dedicated and tireless efforts of those involved in the successful organization of this international conference. I want to thank the distinguished judges who served as moderators to various panels, as well as the erudite and insightful panelists for their invaluable contributions. Indeed, none of this would have been possible without the continued support and partnership of the very prestigious Permanent Court of Arbitration, which was established way back in 1899. Of course, we all know that it's situated at the iconic Peace Palace in Hague, Netherlands. The fact that the PCA is the oldest surviving institution for international dispute resolution underlines its legacy, stature, and significance. In a world where divisions can often seem insurmountable, the Permanent Court of Arbitration continues to remind us of the value of coming together and finding common grounds. PCA holds the distinction of being the first permanent intergovernmental organization to provide a forum for the resolution of international disputes through arbitration and other peaceful means. With over a century of quick and steady work, it has helped nations, businesses, and individuals resolve their differences in a way that fosters trust, dialogue, and fairness. It has become more than just an institution, it is a symbol of hope, where conflicts that may otherwise spiral into crisis are brought to the table of reasoned discussion and resolution. As India continues to grow its stature as an important player on the global legal stage, our association with the Permanent Court of Arbitration serves as a reflection of our commitment to these ideals. It also testifies our endeavors towards encouraging institutional arbitration and promoting India as a hub of international commercial arbitration. Here I would like to put a note with pleasure that the 4 Indian appointments to the roster of the Permanent Court of Arbitration are all retired Supreme Court or High Court justices. It is equally heartening to observe that as per the PCA annual report of 2023, it administered 246 cases, out of which 7 were interstate arbitrations, 2 were other interstate proceedings, 122 were investor-state arbitrations arising under bilateral or multilateral investment treaties or national investment laws, and 110 were arbitrations arising under contracts involving a state, intergovernmental organization, or other state entity. This is a marked increase from 204 cases the PCA administered in 2022. This statistic clearly exemplifies the growing move towards arbitration across the world, along with ever-expansive significance of PCA in facilitating such dispute resolution. This international event on arbitration is but one manifestation of our alliance with the PCA, and as the conference draws to a close that we are closing with this ceremony, I must acknowledge the success that the highlights of the past 3 days would speak. The 7 enlightening working sessions that were witnessed during this event saw participation from leading jurists, consuls, and academicians, not only from India but from across the world. It is precisely this kind of global dialogue and ideal among the judges, arbitrators, academicians, lawyers, and other practitioners that the ideas they discuss, I truly believe, breeds the best ideas and solutions to the pressing problem of the field. By considering both investor-state arbitration and state versus state arbitration. This conference has provided valuable insights to varied problems plaguing the arbitration process in the contemporary world. I was also quite intrigued to observe that a few sessions even explored the investor-state dispute settlement process and the post-award enforcement stage of arbitral proceedings, both of which concern complex legal and political issues and definitely have concerned legal scholars and businesses for decades. Similarly, panels on India's unique tryst with arbitration and the fundamentals of arbitration treaty making have proven to be equally illuminating and engaging. While the prevailing discussions have revealed several pressing challenges that arbitration faces today, given the enthusiasm presented by every participant of this conference, exchange of insights and best practices leave no room to doubt in my mind that the future of arbitration is in safe hands. As we reflect on the fascinating discussions we have had, it becomes clear that these conversations are not just academic and theoretical, but are deeply relevant to the evolving landscape of arbitration worldwide. It is no secret that the past few decades have witnessed a resounding boom of arbitration across the world. Arbitration has quickly become the most favored form of alternative dispute resolution. I am reminded here of a timeless quote of Nachman of Breslev, and he said beautifully, I quote, "Arbitration is justice blended with charity." Today we see that arbitration, despite attempts to confine it within legal frameworks or restrict its scope, endures as a fundamental expression of voluntary cooperation between states or individuals. At its core, arbitration is the conscious decision to entrust the resolution of a dispute to the chosen arbitrators with a prior commitment to abide by their rulings. By willingly engaging in arbitration, parties assert their agency and affirm their capacity to govern their affairs without any external interference. Today, India stands at the threshold of a new era in arbitration. Not only is it rapidly becoming a preferred mode of dispute settlement in our country, but it is also receiving ever increasing infrastructural support, illustrated by the recent establishment of the Arbitration Bar of India, the responsibility Mr. Gaurav Banerjee is also looking after. India's commitment towards international arbitration and enforcement of foreign arbitral awards has always been beyond doubt and is reflected by the fact that India was among the only 6 Asian countries to sign the Geneva Convention and was also among the 10 original signatories to the New York Convention. The legal intricacies about that the learned Solicitor General has just now explained to you. At this stage, however, I would like to flag a small caveat that arbitration itself is by no means a novelty for the Indian subcontinent. The rich tapestry of Indian history finds several mentions of the arbitration process, and traces of arbitration can be found in our oldest adjudication processes carried out at the lowest rungs of the judicial ladder. Moving ahead, it gives me immense pleasure to note that this auspicious occasion signals a bright future for arbitration in India. The establishment of a permanent court of arbitration office in India marks another paradigm shift in our journey towards becoming a hub for international arbitration. This development is another testament to India's growing reputation as a preferred destination for dispute resolution. With PCA's presence, we can expect a surge in international parties choosing India as a seat for arbitration, drawn by the credibility and expertise that PCA brings here. However, this is not just about attracting foreign parties, but also making arbitration more accessible to our own businesses and individuals. No longer will they have to navigate complex logistical hurdles and incur significant costs to access PCA's services. With a local office, we can tap into PCA's expertise and resources right here in India. Moreover, PCA's presence will help build capacity in our arbitration ecosystem. Through training and development programs, we can enhance the skills of our arbitrators, counsel, and other stakeholders, creating a robust and efficient dispute resolution mechanism. As we move forward, let us embrace this opportunity with a passionate dedication. Let us hold the key jointly and unlock new avenues so as to create an ease of arbitration that is truly world-class, one that will serve as a beacon for dispute resolution in the region and beyond. A key takeaway from our sessions is the need for continued cooperation between international and domestic arbitration bodies. This collaboration is essentially for upholding the integrity of arbitration and reinforcing the rule of law. By working together, we can address the complexities and challenges that arise, ensuring that arbitration remains a fair, efficient, cost-effective, and accessible means of dispute resolution. Our commitment to the strengthening international legal framework has never been more crucial. Both India and the global arbitration community stand united in their dedication to enhancing and evolving these frameworks. Through shared efforts and a collective vision, we can build a more cohesive and reliable system that serves the needs of all parties involved. I would like to once again extend my heartfelt gratitude to the organizers, panelists, and participants who have given their time, expertise, and passion to these important conversations. Your dedication has made this conference a resounding success and has provided invaluable insights into the future of arbitration. As we all come to the formal conclusion of this conference, I would like to express my fond hope that the interactions this weekend merely signaled the beginning of a future which is full of productive collaborations between the Supreme Court of India and the Permanent Court of Arbitration. This milestone event clearly marks the dawn of a new era in the arbitration in India. Together, we will navigate the evolving landscape of arbitration and work towards a more just and equitable global legal system. I would also urge you all to carry forward the remarkable conversations this conference has sparked and to stay connected to one another. As the famous English playwright John Henwood once said, and I quote, "Rome was not built in a day, but they were laying bricks every hour." With consistent efforts by all the stakeholders involved, I have no doubt in my mind that India can become the new arbitral center of the world. Thank you very much. Thank you. Good day.
Thank you, Honorable Mr. Justice Suryakant. As we conclude this exceptional conference, I would like to extend our heartfelt gratitude to the Honorable Chief Justice of India, Honorable Dr. Justice D.Y. Chandrachud, and other Honorable Judges of the Supreme Court of India for their valued contributions and giving us the opportunity to host this conference in the Supreme Court. A special thank you goes to our distinguished international speakers for coming to India. Your expertise have enriched our discussions. I would also like to thank my colleagues from the Permanent Court of Arbitration, Dr. Tullio and Sandra. I would also like to extend a special thank you to the organizers, especially Mr. Atul Korekar, Secretary General, Supreme Court of India, Mr. Rakesh Kumar, Registrar, International Relations, Supreme Court of India, Mr. H.S. Jaggi, Registrar, Computer Cell, Mr. Mahesh Patakar, Registrar Admin General, Supreme Court of India, and the whole team of Supreme Court of India, the volunteers whose efforts behind the scenes have ensured the smooth and successful execution of this conference. I would also like to extend gratitude to each and every one of you for your participation and contributions. With that, I officially declare the Conference on International Arbitration and Rule of Law closed. Thank you once again for being here and for your commitment to advancing international arbitration. Safe travels, and we hope to see you at future events. Thank you. I would request everybody to join us for high tea outside this auditorium. Thanks.